Article 2. Application of its provisions. Except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction, against those who 1. Should commit an offense while on a Philippine ship or airship. 2. Should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. 3. Should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. 4. While being public officers or employees, should commit an offense in the exercise of their functions, or 5. Should commit any of the crimes against national security and the law of nations, defined in Title I of Book 2 of this Code. Article 3. Definition. Acts and omissions punishable by law are felonies or delitos. Felonies are committed not only by means of deceit or dolo but also by means of fault or culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Article 4. Criminal liability. Criminal liability shall be incurred 1. By any person committing a felony or delito, although the wrongful act done be different from that which he intended. 2. By any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Article 6. Consummated, frustrated, and attempted felonies. Consummated felonies, as well as those which are frustrated and attempted, are punishable. A felony is consummated when all the elements necessary for its execution and accomplishment are present, and it is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which, nevertheless, do not produce it by reason of causes independent of the will of the perpetrator. There is an attempt when the offender commences the commission of a felony directly by overt acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Article 8. Conspiracy and proposal to commit felony. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefor. A conspiracy exists when 2 or more persons come to an agreement concerning the commission of a felony and decide to commit it. Article 9. Grave felonies, less grave felonies, and light felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive, in accordance with Article 25 of this Code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional, in accordance with the above-mentioned article. Light felonies are those infractions of law for the commission of which the penalty of arresto menor or a fine not exceeding 40,000 pesos, or both, is provided. Article 11. Justifying circumstances. The following do not incur any criminal liability. 1. Anyone who acts in defense of his person or rights, provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. 2. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the 4th civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite, in case the provocation was given by the person attacked, that the one making defense had no part therein. 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. 4. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. 2. A person under 9 years of age. 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this Code. When such minor is adjudged to be criminally irresponsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. 5. Any person who acts under the compulsion of irresistible force. 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. 7. Any person who fails to perform an act required by law when prevented by some lawful insuperable cause. Article 13. Mitigating circumstances. The following are mitigating circumstances. 1. Those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. 2. That the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. 3. That the offender had no intention to commit so grave a wrong as that committed. 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, descendants, legitimate, natural or adopted brothers or sisters or relatives by affinity within the same degrees. 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. 8. That the offender is deaf and dumb, blind or otherwise suffering some physical defect which thus restricts his means of action, defense, or communication with his fellow beings. 9. Such illness of the offender as would diminish the exercise of the willpower of the offender without however depriving him of consciousness of his acts. 10. And finally, any other circumstance of a similar nature and analogous to those above mentioned. Article 14. Aggravating circumstances. The following are aggravating circumstances. 1. That advantage be taken by the offender of his public position. 2. That the crime be committed in contempt of or with insult to the public authorities. 3. That the act be committed with insult or in disregard of the respect due to the offended party on account of his rank, age, or sex, or that it be committed in the dwelling of the offended party, if the latter has not given provocation. 4. that the act be committed with abuse of confidence or obvious ungratefulness. 5. That the crime be committed in the palace of the chief executive, or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. 6. That the crime be committed in the nighttime, or in an uninhabited place, or by a band, whenever such circumstances may facilitate the commission of the offense. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. 7. That the crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. 8. That the crime be committed with the aid of armed men or persons who ensure or afford impunity. 9. That the accused is a recidivist. A recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of this code. 10. That the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty. 11. That the crime be committed in consideration of a price, reward, or promise. 12. That the crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel or intentional damage thereto, derailment of a locomotive, or by the use of any other artifice involving great waste and ruin. 13. That the act be committed with evident premeditation. 14. That craft, fraud, or disguise be employed. 15. That advantage be taken of superior strength, or means be employed to weaken the defense. 16. That the act be committed with treachery, alavosia. There is treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof which tend directly and specially to ensure its execution, without risk to himself arising from the defense which the offended party might make. 17. That means be employed or circumstances brought about which add ignominy to the natural effects of the act. 18. That the crime be committed after an unlawful entry. There is an unlawful entry when an entrance is effected by a way not intended for the purpose. 19. That as a means to the commission of a crime a wall, roof, floor, door, or window be broken. 20. That the crime be committed with the aid of persons under 15 years of age, or by means of motor vehicles, motorized watercraft, airships, or other similar means. 21. That the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Article 17. Principles. The following are considered principles. 1. Those who take a direct part in the execution of the act. 2. Those who directly force or induce others to commit it. 3. Those who cooperate in the commission of the offense by another act without which it would not have been accomplished. Article 18. Accomplices. Accomplices are those persons who, not being included in Article 17, cooperate in the execution of the offense by previous or simultaneous acts. Article 20. Accessories who are exempt from criminal liability. The penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article. Article 48. Penalty for complex crimes. When a single act constitutes 2 or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Article 91. Computation of prescription of offenses. The period of prescription shall commence to run from the day on which the crime is discovered by the offended party, the authorities, or their agents, and shall be interrupted by the filing of the complaint or information, and shall commence to run again when such proceedings terminate without the accused being convicted or acquitted, or are unjustifiably stopped for any reason not imputable to him. The term of prescription shall not run when the offender is absent from the Philippine archipelago. Book 2. Article 132. Interruption of religious worship. The penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. If the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. Article 134. Rebellion or insurrection. How committed? The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws, the territory of the Republic of the Philippines or any part thereof, of any body of land, naval, or other armed forces, or depriving the chief executive, or the legislature, wholly or partially, of any of their powers or prerogatives. Article 142. Inciting to sedition. The penalty of prison correctional in its maximum period and a fine not exceeding 400,000 pesos shall be imposed upon any person who, without taking any direct part in the crime of sedition, should incite others to the accomplishment of any of the acts which constitute sedition, by means of speeches, proclamations, writings, emblems, cartoons, banners, or other representations tending to the same end, or upon any person or persons who shall utter seditious words or speeches, write, publish, or circulate scurrilous libels against the government, or any of the duly constituted authorities thereof, or which tend to disturb or obstruct any lawful officer in executing the functions of his office, or which tend to instigate others to cabal and meet together for unlawful purposes, or which suggest or incite rebellious conspiracies or riots, or which lead or tend to stir up the people against the lawful authorities or to disturb the peace of the community, the safety and order of the government, or who shall knowingly conceal such evil practices. Article 148. Direct assaults. Any person or person who, without a public uprising, shall employ force or intimidation for the attainment of any of the purposes enumerated in defining the crimes of rebellion and sedition, or shall attack, employ force, or seriously intimidate or resist any person in authority or any of his agents, while engaged in the performance of official duties, or on occasion of such performance, shall suffer the penalty of prison correctional in its medium and maximum periods, and a fine not exceeding 200,000 pesos when the assault is committed with a weapon or when the offender lays hand upon a person in authority. If none of these circumstances be present, the penalty of prison correctional in its minimum period and a fine not exceeding 100,000 pesos shall be imposed. Article 151. Resistance and disobedience to a person in authority or the agents of such person. The penalty of arresto mayor and a fine not exceeding 100,000 pesos shall be imposed upon any person who, not being included in the provisions of the preceding articles, shall resist or seriously disobey any person in authority or the agents of such person while engaged in the performance of official duties. When the disobedience to an agent of a person in authority is not of a serious nature, the penalty of arresto menor or a fine ranging from 2,000 pesos to 20,000 pesos shall be imposed upon the offender. Article 152. Persons in authority and agents of persons in authority, who shall be deemed as such. In applying the provisions of the preceding and other articles of this code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed a person in authority. Article 157. Evasion of service of sentence. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any convict who shall evade service of a sentence by escaping during the term of his imprisonment by reason of final judgment. However, if such evasion or escape shall have taken place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, floors, or by using picklocks, false keys, disguise, deceit, violence, or intimidation, or through connivance with other convicts or employees of the penal institution, the penalty shall be prison correctional in its maximum period. Article 171. Falsification by public officer, employee or notary or ecclesiastic minister. The penalty of prison mayor and a fine not to exceed 1 million pesos shall be imposed upon any public officer, employee, or notary who, taking advantage of his official position, shall falsify a document by committing any of the following acts. 1. Counterfeiting or imitating any handwriting, signature, or rubric. 2. Causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. 3. Attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. 4. Making untruthful statements in a narration of facts. 5. Altering true dates. 6. Making any alteration or intercalation in a genuine document which changes its meaning. 7. Issuing in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to, or different from, that of the genuine original, or 8. Intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official book. The same penalty shall be imposed upon any ecclesiastical minister who shall commit any of the offenses enumerated in the preceding paragraphs of this article, with respect to any record or document, of such character that its falsification may affect the civil status of persons. Article 172. Falsification by private individual and use of falsified documents. The penalty of prison correctional in its medium and maximum periods and a fine of not more than 1 million pesos shall be imposed upon 1. Any private individual who shall commit any of the falsifications enumerated in the next preceding article in any public or official document or letter of exchange or any other kind of commercial document. 2. Any person who, to the damage of a third party, or with the intent to cause such damage, shall in any private document commit any of the acts of falsification enumerated in the next preceding article, and 3. Any person who shall knowingly introduce an evidence in any judicial proceeding or to the damage of another or who, with the intent to cause such damage, shall use any of the false documents embraced in the next preceding article, or in any of the foregoing subdivisions of this article, shall be punished by the penalty next lower in degree. Article 210. Direct bribery. Any public officer who shall agree to perform an act constituting a crime, in connection with the performance of his official duties, in consideration of any offer, promise, gift, or present received by such officer, personally or through the mediation of another, shall suffer the penalty of prison correctional in its minimum and medium periods, and a fine of not less than the value of the gift and not more than 3 times such value, in addition to the penalty corresponding to the crime agreed upon, if the same shall have been committed. If the gift was accepted by the officer in consideration of the execution of an act which does not constitute a crime, and the officer executed said act, he shall suffer the same penalty provided in the preceding paragraph, and if said act shall not have been accomplished, the officer shall suffer the penalties of arresto mayor in its maximum period, and a fine of not less than the value of the gift, and not more than twice such value. If the object for which the gift was received or promised was to make the public officer refrain from doing something which it was his official duty to do, he shall suffer the penalties of arresto mayor in its medium and maximum periods, and a fine of not less than the value of the gift, and not more than 3 times such value. In addition to the penalties provided in the preceding paragraphs, the culprit shall suffer the penalty of special temporary disqualification. The provisions contained in the preceding paragraph shall be made applicable to assessors, arbitrators, appraisal and claim commissioners, experts, or any other persons performing public duties. Article 211. Indirect bribery. The penalties of arresto mare, suspension in its minimum and medium periods, and public censure shall be imposed upon any public officer who shall accept gifts offered to him by reason of his office. Article 212. Corruption of public officials. The same penalties imposed upon the officer 9. Corrupted, except those of disqualification and suspension, shall be imposed upon any person who shall have made the offers or promises or given the gifts or presents as described in the preceding articles. Article 217. Malversation of public funds or property. Presumption of malversation. Any public officer who, by reason of the duties of his office, is accountable for public funds or property, shall appropriate the same, or shall take or misappropriate, or shall consent, through abandonment or negligence, shall permit any other person to take such public funds or property, wholly or partially, or shall otherwise be guilty of the misappropriation or malversation of such funds or property, shall suffer the failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable, upon demand by any duly authorized officer, shall be prima facie evidence that he has put such missing funds or property to personal uses. Article 220. Illegal use of public funds or property. Any public officer who shall apply any public fund or property under his administration to any public use other than that for which such fund or property were appropriated by law or ordinance shall suffer the penalty of prison correctional in its minimum period, or a fine ranging from 1/2 to the total value of the sum misapplied, if by reason of such misapplication any damage or embarrassment shall have resulted to the public service. In either case, the offender shall also suffer the penalty of temporary special disqualification. If no damage or embarrassment to the public service has resulted, the penalty shall be a fine from 5 to 50% of the sum misapplied. Article 223. Conniving with or consenting to evasion. Any public officer who shall consent to the escape of a prisoner custody or charge shall be punished by prison correctional in its medium and maximum periods, and temporary special disqualification in its maximum period to perpetual special disqualification, if the fugitive shall have been sentenced by final judgment to any penalty. By prison correctional in its minimum period and temporary special disqualification, in case the fugitive shall not have been finally convicted, but only held as a detention prisoner for any crime or violation of law or municipal ordinance. Article 246. Parricide. Any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his ascendants or descendants, or his spouse, shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. Article 247. Death or physical injuries inflicted under exceptional circumstances. Any legally married person who, having surprised a spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable, under the same circumstances, to parents with respect to their daughters under 18 years of age and their seducers, while the daughters are living with their parents. Any person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse shall not be entitled to the benefits of this article. Article 248. Murdered. Any person who, not falling within the provisions of Article 246, shall kill another, shall be guilty of murder and shall be punished by reclusion temporal in its maximum period to death, if committed with any of the following attendant circumstances: with treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense, or of means or persons to ensure or afford impunity, in consideration of a price, reward, or promise, by means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity, with evident premeditation, with cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Article 249. Homicide. Any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article, shall be deemed guilty of homicide and be punished by reclusion temporal. Article 255. Infanticide. The penalty provided for parricide in Article 246 and for murder in Article 248 shall be imposed upon any person who shall kill any child less than 3 days of age. If the crime penalized in this article be committed by the mother of the child for the purpose of concealing her dishonor, she shall suffer the penalty of prison correctional in its medium and maximum periods, and if said crime be committed for the same purpose by the maternal grandparents or either of them, the penalty shall be prison mere. Article 257. Unintentional abortion. The penalty of prison correctional in its minimum and medium periods shall be imposed upon any person who shall cause an abortion by violence, but unintentionally. Article 267. Serious illegal detention. Any private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion temporal, if the locking up or detention shall have lasted more than 20 days, if it shall have been committed simulating public authority, if any serious physical injuries shall have been inflicted upon the person locked up or detained, or if threats to kill him shall have been made. Article 282. Grave threats. Any person who shall threaten another with the infliction upon the person, honor, or property of the latter or of his family of any wrong amounting to a crime, shall suffer 1. The penalty next lower in degree than that prescribed by law for the crime he threatened to commit, if the offender shall have made the threat demanding money or imposing any other condition, even though not unlawful, and said offender shall have attained his purpose. If the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. If the threat be made in writing or through a middleman, the penalty shall be imposed in its maximum period. 2. The penalty of arresto mare and a fine not exceeding 100,000 pesos if the threat shall not have been made subject to a condition. Article 286. Grave coercions. The penalty of prison correctional and a fine not exceeding 100,000 pesos shall be imposed upon any person who without any authority of law shall, by means of violence, threats, or intimidation, prevent another from doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong. If the coercion be committed in violation of the exercise of the right of suffrage, or for the purpose of compelling another to perform any religious act, or to prevent him from exercising such right or from so doing such act, the penalty next higher in degree shall be imposed. Article 287. Light coercions. Any person who, by means of violence, shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt, shall suffer the penalty of arresto mare in its minimum period and a fine equivalent to the value of the thing, but in no case less than 15,000 pesos. Any other coercions or unjust vexations shall be punished by arresto menor or a fine ranging from 1,000 pesos to not more than 40,000 pesos, or both. Article 294. Robbery with violence against or intimidation of persons. Penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer. Article 295. Robbery with physical injuries, committed in an uninhabited place and by a band. If the offenses mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place and by a band, or by attacking a moving train, streetcar, motor vehicle, or airship, or by entering the passengers' compartments in a train, or, in any manner, taking the passengers thereof by surprise in the respective conveyances, the offender shall be punished by the maximum period of the proper penalities. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of a robbery, it shall be deemed to have been committed by a band. Any member of a band who is present at the commission of a robbery in an uninhabited place and by a band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery a homicide is committed, the person guilty of such offenses shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Article 308. Who are liable for theft. Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by 1. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. 2. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him. And 3. Any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another and without the consent of its owner, shall hunt or fish upon the same or shall gather fruits, cereals, or other forest or farm products. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher in degree than those respectively specified in the next preceding article, if committed by a domestic servant, or with grave abuse of confidence, or if the property stolen is large cattle or consists of coconuts, or fish taken from a fish pond or fishery. Article 315. Swindling estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by, provided that in the 4 cases mentioned, the fraud be committed by any of the following means. With unfaithfulness or abuse of confidence, namely, by altering the substance, quantity, or quality of anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. By misappropriating or converting, to the prejudice of another, money, goods, or any other personal property received by the offender in trust or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank, to the prejudice of the offended party or any third person. By means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. By altering the quality, fineness, or weight of anything pertaining to his art or business. By pretending to have bribed any government employee, without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. By post-dating a check, or issuing such check in payment of an obligation, the offender knowing that at the time he had no funds in the bank, or the funds deposited by him in the bank were not sufficient to cover the amount of the check, and without informing the payee of such circumstances. Through any of the following fraudulent means: by inducing another, by means of deceit, to sign any document, by resorting to some fraudulent practice to ensure success in a gambling game, by removing, concealing, or destroying, in whole or in part, any court record, office files, document, or any other papers. Article 320. Destructive arson. The penalty of reclusion temporal in its maximum period to reclusion perpetua shall be imposed upon any person who shall burn any arsenal, shipyard, storehouse, or military powder or fireworks factory, ordnance storehouse, archives, or general museum of the government, any passenger train or motor vehicle in motion, or vessel out of port, in an inhabited place, any storehouse or factory of inflammable or explosive materials, any theater, church, cockpit, or other building where meetings are held, when occupied by a numerous assemblage. Article 333. Who are guilty of adultery. Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum periods. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Article 334. Concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. Article 335. When and how rape is committed. Rape is committed by having carnal knowledge of a woman under any of the following circumstances: by using force or intimidation, when the woman is deprived of reason or otherwise unconscious, and when the woman is under 12 years of age, even though neither of the circumstances mentioned in the two next preceding paragraphs shall be present. The crime of rape shall be punished by reclusion temporal. Article 336. Acts of lasciviousness. Any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, shall be punished by prison correctional. Article 353. Definition of libel. A libel is a public and malicious imputation of a crime, or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead.